Right. Happy Tuesday! And don't touch that dial. Don't touch the remote control. It is another episode of SEIU Says, the weekly union news show dedicated to our union workers and non-union workers and the communities they live in. We have a guest today, and this is attorney
Donn LaHaie.
All right. We want you to sit back and enjoy an episode of SEIU Says.
We shall not be moved. We shall not be moved, just like a tree that's planted by the waters. We shall not be moved. We're fighting for a contract. We shall not be moved. We're fighting for a contract. We shall not be moved, just like a tree that's planted by the waters. We shall not be moved. We're stronger together, we shall not be moved. We're stronger together, we shall not be moved. Just like a tree that's planted by the waters. We shall not be moved. We're fighting for an increase, we shall not be moved. We're fighting for an increase, we shall not be moved. Just like a tree that's planted by the waters. We shall not be moved.
That's right. We shall not be moved. Why? Because we are stronger together. And I hope everyone had a wonderful weekend. I'm Charlie Bonds. I'm your host tonight for SEIU Says. SEIU Says is the weekly union news show, and this show is sponsored by GWC. That's Goldberg, Weissman, and Cairo. That's Illinois' largest personal injury and workers' compensation law firm. If you have any questions about workers' comp, or you may feel that you may have a case, or you may know someone that have a case, then we have a guest today from Goldberg, Weissman, and Cairo, and this is attorney, once again,
Donn LaHaie.
All right, and he's going to be here answering questions for all of our friends out there today that may have questions about workers' comp. And then we have some in-house questions that we want to ask him so we can get people enlightened on workers' comp. So that is GWC, Goldberg, Weissman, and Cairo, Illinois' largest personal injury consulting firm. All right, now, as I always say, when you work hard and you work Monday through Friday, or Tuesday through Saturday, or whatever, if you're working, it's time to play hard. If you come home and you want to relax, well, I've got great news for you. Mark your calendars, everybody, because it is time for the SEIU Local 73 2014 picnic. That's right. It is going to be free food. It is going to be free beer, raffle, music, and dancing and games for your kids. That is right. So you want to come out to the SEIU Local 73 picnic. And you may say, when is that date for that picnic, Charlie? Well, that date is Saturday, January the 28th, 2014. What time is the picnic, Charlie? The picnic is 11 o'clock from 11 to 5 p.m. and it's going to be at 2199 South 1st Avenue in Maywood, Illinois. So bring your sunscreen, bring a lawn chair, bring an appetite, and bring the mindset to have a good time. If you need directions on how to get to that event, or extravaganza as we like to call it, then I encourage you, get a pen, everyone, to visit SEIU Local 73's website. And that website is that's World Wide Web, www.seiu73.org. That's www.seiu73.org. And when you go visit that website, you can pull up our members picnic, because we have a picnic for Chicago that day. We have a picnic for the Indiana office as well. So you may need to get instructions on how to get there, and you want basically, find times and everything like that. Then go visit our website and you will get that information. Okay, I have another announcement to make. The West Chesterfield. All right, so if you live in these areas here, I'm going to announce it. If you live in the neighborhood of Burnside, Chatham, Chesterfield, Pullman, Riverdale, Roseland Heights, Rosemore, Vernon Park, or West Pullman, the West Chesterfield has a community party that will be coming up. And the date for this party will be Saturday, July the 19th, 2014 from 10 a.m. to 3 p.m. So it's going to be really nice. They're going to have a children's petting zoo. So it's going to be a live petting zoo so you can bring your children out. If a lot of children in the city may have not had the opportunity to be exposed to different types of animals, then you can bring them out to this petting zoo. There's going to be a doggy social. So if you have a dog, if you're a dog person, I'm a dog person, so you can bring your dog out to the doggy social. There's going to be a doggy social that day as well. There's going to be Chicago fire truck jumping jacks. So they're going to be doing jumping jacks on fire trucks. There's going to be a basketball court. So it is a party. It is party time. So you may want information on this. It's going to be food, music, petting zoo, doggy social, cheerleading, basketball, classic cars, and motorcycle rodeo race. It's a whole lot of stuff going on that day. So you need to mark your calendars for Saturday, July 19th, 2014. I'm sorry, this is SEIU Says, and we have a caller. This is SEIU Says. Happy Tuesday.
This is SEIU caller. This is SEIU Says.
Yes. I'm calling to ask about, I'm in the union as well at a nursing home.
Okay.
I didn't hurt myself at work, but I was on my way to work when I did get hurt. Okay. And I had, worked, went on through my day, everything. When I got off of work,
Can you turn the television down a little bit, please? I'm sorry.
They told me I was going to be on light duty. My TV is on mute.
Okay.
I don't know what. Also, I wanted to say, when I let the job know that the hospital said I should be on light duty, they were saying, "Oh well, that's you work on light duty on your own terms. Since you didn't get hurt on the job, basically that's not their problem." But when I got hurt, I was like in the driveway. Someone hit my car, and then I went on and clocked in, and I continued to work because I didn't feel pain, but. Is that something I should call a lawyer about, or should I just let it go? And if the pain persists, then contact someone on the job. If they even take into consideration that I could have been in much more pain. The only thing that happened was like a muscle spasm.
Okay. Well, you can definitely call GWC. We'd be happy to answer any questions you have. The question as to whether your light duty has to be accommodated really revolves upon whether it was a work injury or not. And it's a really complex question that you pose, even though you were on your way to work. If you weren't actually doing something related to work when you got injured, you're probably not covered under workers' comp. But if someone else was at fault for the injury, even though you may not have a workers' comp claim, you may have a third-party lawsuit against the person who was actually liable for causing the injuries that you sustained. But there are a bunch of fact-specific questions that we'd be happy to ask you and answer for you to determine whether you have a workers' compensation claim. It does become a gray area and very complex based on your set of circumstances. So I would recommend that you call GWC and speak to an attorney individual. We can spend a little time going through your questions and answer the questions that you have specifically to make sure you're in the right direction legally.
Okay.
Well, thank you very much for that information. That really just helped.
You're welcome.
Okay. We thank you very much. All right, so we got the workers' comp guru right here. All right. So I want to finish this announcement. The West Chesterfield Community Party. So if you live in those areas and you are available Saturday, July 19th from 10 a.m. to 3 p.m. and you want to take your children out to have a wonderful time with the petting zoo and all the other activities, then you come on out. That phone number, get a pen, will be 773-821-8928. That phone number is 773-821-8928, and that's for the West Chesterfield Community Party coming up. Now, I have another announcement to make really fast. Is Cal. As you know, I don't know, some of you all may not be aware of that. I don't know if you can see this picture really well, but What it is CAL. CAL is a community organization, a grassroots community organization located within inside of SEIU Local 73. And then what we want to do here is we're trying to cultivate those conversations, stimulate conversations within the communities that it's time to bring about change, as far as the alderman election is getting ready to come up, the mayor's election is getting ready to come up. And there are a lot of issues that are going on within inside of the city. How does the city get changed? Because the people promote change. People within the city want to see change. People within the city, they have one mindset to bring about this. And so if you are interested, if you are an activist, if you are a leader, if you just want to see, like I say, bring about change, then we encourage you to come to the meeting this Saturday at SEIU Local 73, and it's CAL. It's Communities Organized to Win. It's a grassroots foundation, grassroots organization with a grassroots foundation as well. And so that meeting is going to be, I'm going to get you the times really fast. The meeting is going to be, so you're going to need to RSVP for this meeting, and it's very important. The phone number is 312-588-7620. Don't wait for someone else to bring about change. You can bring about change. As we talked about last week, we had Pastor Corey Brooks here. One man can do something. One person can do something. So if you feel as if though it's time to bring about that change, and you got the mindset, the energy, the insight, the ideals to do it, then we want to see you at that meeting this Saturday. That number to RSVP will be 312-588-7620, and do so by Friday the 13th. And we need a head count, and we're going to have refreshments. So we definitely want to see you. The times are going to be from 10 a.m. until 1 p.m. Please arrive no later than 9:45, and we're going to talk about a lot of the project. We have a pilot project coming up involving communities, the aldermanic candidates. So we're going to be talking about a lot of that, because a lot of those things are coming up. All right, so we're going back to our guest today. Happy Tuesday, everybody, once again, and we thank you for letting us into your homes today. So as you know, workers' comp, and we're going to just get a foundation of workers' comp for some people out there in television land that may not know. If you're streaming us live on the internet as well, we like to say good evening tonight. So what is workers' comp?
Workers' comp, Charlie, is a system in which people who get hurt on the job can be compensated.
Okay.
It's a no-fault system. Basically means that if you're working, you're doing something work-related while you're working at the job, and you sustain an injury, whether it be a traumatic injury or repetitive type of trauma, you receive compensation.
Okay, so that is the definition of workers' comp. Okay, so how long does an employee have to report a workers' comp claim?
Under the law, you have 45 days to report an injury.
Okay.
Obviously, the correct answer is reported immediately.
Report me. So we're creating this. So hypothetically, let's say I work at the soap company, and I'm walking my break, and I happen to slip on some soap, and I hurt myself. And I'm at work while I'm working at the soap company. All right. And so at that moment, I should report that injury immediately. Correct.
Correct. Report it to your supervisor.
Report it to your supervisor.
Exactly.
Okay. Mm-hmm. All right. And you legally by law, you have 45 days to do so. But it always looks good, because you are in pain with that. You want to report that immediately. All right. Okay. So I have another question. What if there is no witnesses to the injury or accident at work? How do you deal with that?
It's okay. A lot of injuries are unwitnessed. There's some injuries such as repetitive trauma, which, by necessity, there are no witnesses. It's okay. You are the witness. You're the one who sustained the injury. You're the one reporting it. If there are witnesses, obviously that's helpful. You want to get their names and numbers and record that. But it's not fatal to a workers' comp case just because there are no witnesses.
Okay. How long does it take to get approved for my workers' comp?
Okay, technically, what you do is you report it, as we said. Your employer then would report it to their workers' compensation carrier, which is the insurance company. Technically, there are 14 days in which the insurance company has to start applying benefits. So, in the benefits, we kind of glossed over that. There's 3 benefits under workers' comp. Number 1 is TTD, which is payments for time off. It's 2/3 of your pay. Number 2 is your medical bills. All of your medical bills that are reasonably related to the injury will be compensated compensated. And then thirdly, at the end of the case, if you've sustained a permanent disability, you would get a disability award. Okay. So as I was saying, you have 14 days is typically when the insurance company is supposed to start paying you. However, there can be delays due to the failure of the employer to report it, investigation. There's a lot of things that can occur in the interim. So the typical way this should go down is you sustain an injury, you report it, get medical care, the best medical care you can right away, and then call an attorney. And of course, we'd like you to call GWC.
Okay, I definitely call GWC. Okay, I had another question. Okay, so if you think a job description that you're currently doing right now that may cause, because I like to believe in preventive measures, may cause a problem in the future, what can you do to prevent a workers' comp case? Like a perfect example, I guess, is like carpal tunnel. What can you do, and we just don't want to limit it to that. So you see yourself and you know because you know your body and you know the changes that could possibly happen. What can you do to stop a case from happening, because ultimately you don't want to get hurt on the job? What will be some helpful tips for that?
Yeah, if you're doing something that's inherently dangerous or something that you know is injuring you or could injure you in the future, you want to report that as well. You want to report it to your employer. You want to ask for an accommodation, a reasonable accommodation. Oftentimes the employer, and most employers are sensitive to this. Insurance companies are certainly sensitive to this. And certain things can be done. They can give you a different chair. They can give you ergonomic keyboards. There's all kinds of things that can be given and adaptations that can be made. So that's certainly reasonable to make that request upon your employer. And if they're smart, they'll do it.
Okay, so if you see, how people, you may get that. If you foresee it, then you can start making requests now before you get that severe with it, where you have to be out of work.
Yeah, you can make that request. Workers' comp there's no enforcement within workers' comp to force the employer to make these measures to prevent an injury. But certainly for your own health and safety, it's a request that you can make.
Okay, very good. So you can make that request. All right. So I have another question. Do you have to use your personal benefit time while you're on workers' comp?
Okay, the flat answer is no. You shouldn't have to use any of your personal time on your workers' comp.
Okay.
When you go off on workers' comp and you're injured and you're going to be off for a period of time, the first 3 days you're off are not compensable. So you're going to lose the first 3 days.
Okay.
Unless you're off for 14 consecutive days. So if you're going to be off for 14 or more days, then workers' comp goes back and picks up the first 3. So if
it's retroactive.
It's retroactive, correct.
Okay.
So if you're off for just a brief period of time and the injury isn't that serious and you just miss, say, 5-6 days of work, and the first 3 days are not compensable, if you want to use your sick days, you certainly could, or your personal time, whatever.
Okay.
But by law, you should not have to lose that if you're off for workers' comp.
Okay, so the rule is, so if I hurt myself at the soap company again, all right, so I'm only off for 5 days. 3 of those days I would have to use my own benefit time if I'm only going to be off for 5 days in total, right?
If you're going to be compensated in any way, you would have to use your personal time.
Okay. So the rule. So in order to have that retroactive back, then you would need to be off 14 consecutive days.
Correct. Yeah.
Okay, 14 consecutive days. Yeah. All right. Okay. So we have, as you know, benefit time, and then the FMLA Act, which stands for Family Medical Leave. Those are something totally different. Do you have to use your FMLA time if you're on workers' comp?
You don't have to use it while you're on workers' comp. You don't have to go to your employer and apply for FMLA leave. However, if your employer says we want you to apply for FMLA leave while you're off on workers' comp benefits, you may do so. It has nothing to do with workers' comp. FMLA leave is an act that just protects your position while you're off work, whether it's work related or family related, personally related, whatever it might be. As we were talking earlier, it's very rare that employers ask you to use FMLA leave during workers' comp, but usually when you get to that point, depending upon your situation, hopefully you'll have counsel, you'll have an attorney at that point, and based on your individual situation at that point, you can consult your attorney, but you don't have to unilaterally seek out FMLA leave while you're on workers' comp.
Okay, we have some more questions, but I just want to say this is Goldberg, Weissman, and Cairo. That's Illinois' largest personal injury and workers' compensation law firm. You're hearing some of the hearing the conversation that we're having today about workers' comp. If you need information on Goldberg, Weissman, and Cairo, you want them to represent you for your workers' comp, or you may have a friend, or you just want to ask those questions, get a pen, and we want to give you that phone number to call. That number is 312-588-7630, and that phone number will take you to SEIU, which stands for Service Employment International Union, the fastest growing union in North America. And so what we will do is this for Local 73, that number 312-588-7630, and we will be more than happy to assist you with that and to get you over to GWC. Okay, so I have some more questions I would like to ask you right here. Okay, so after I'm injured, when I return back to work, and if I have restriction, what is the employer's responsibility to me?
Okay. If you have been injured and your doctor's treating you and the doctor says you still have light duty restrictions or there's some other types of restrictions on your employment, the ball is then in your court to contact the employer and say, hey, employer, I'm ready to come back to work. However, I have these restrictions. And hopefully the doctor will be specific and say no lifting, no bending, whatever the restrictions might be. But it's your obligation to present those to the employer to try to go back to work. Okay? And then the employer then has a choice. They can either accommodate those restrictions or they cannot accommodate those restrictions. So if they accommodate those restrictions, then you go back to work and you do the job within those restrictions. And problems can arise, but we can deal with that as they occur. If the employer refuses to accommodate your restrictions and says, no, we don't want you coming back to work, then you would remain off work and you would continue to receive workers' comp benefits while you're off work recovering fully until you already have a full duty release to return to work.
Okay, so y'all got that? Okay, full duty of release to return back to work if they're giving you problems about your restriction. Because a lot of our members, they do have that problem sometimes where the employer, I'm not going to say the employer's name, but the employer sometimes will like, well, you don't need to come to work if you can't do no work. Go home.
Right.
Yeah.
And that happens a lot. And if that's the case, it's fine because you stay home and you should continue to receive your workers' comp benefits. It actually becomes more problematic when the person returns to work and they're more often than not, there becomes a dispute as to whether the employer is actually accommodating the restrictions. We get these calls all the time. Our clients will go back to work and they will report that the employer is not doing what they're supposed to. They're not letting them do the light duty position or making them do more than they should be doing. And that's certainly another situation. It's not good. And that's certainly
because that could put them in a more liable, another suit.
You can get hurt again and possibly have another workers' comp claim. You can, more importantly, injure yourself even more greatly. So that's another situation where you want to have an attorney because if you don't and you're in that situation, you have no one fighting for you, and it's your word against the companies, and they're the ones who are applying the benefits or supplying the benefits, and you're at a disadvantage in that situation. But we get that all the time, and that's a battle we have to fight all the time.
Don't you all like attorneys? They're so detailed.
Thanks.
Don't you? I mean, yeah, I think they are. They're so detailed. All right. Okay. So, can you be fired while you're on workers' comp?
Well, you can. Everybody, including myself, thinks we have an entitlement to our job, but most of us are at-will employees, which means we can be fired for any reason or no reason. So the technical answer is yes, you can be terminated or fired or whatever terminology you want to use. It's highly unlikely, however, and certainly you can't be fired because you have a workers' comp claim or because you're injured. Okay, you have certain protections. They can't discriminate against you because you filed a workers' comp claim or you have an attorney. But technically, you can be fired. But again, it's very unlikely. There's a lot of ramifications that can occur. And to be honest with you, Charlie, when someone has an attorney, it's highly unlikely that the employer or the insurance company is going to do anything adverse to that person because they've already stood up for their rights. They've already retained an attorney to protect themselves. So and
it's
unlikely.
We're hoping you all will all have that attorney because GWC is in the house. That's right.
Thanks, Charlie.
All right. Okay, so what happens if you can't return to work to perform your duties?
Well, that's in general, that's a very complex question. If you are so disabled that you cannot return to work and do your normal job, you have a difficult case. You are certainly entitled to find alternative employment, but certainly compensation is the most primary concern, and you should be compensated. If you can't return to work and you're permanently disabled in some way, you would be fighting for disability benefits. You may have a wage differential if you have to take a lesser paying job. There's a whole myriad of things that can occur, and that's what we would help you with.
Okay, it was wonderful to have you, and they definitely will be back. So introduce yourself once again.
Donn LaHaie with Goldberg, Weissman, and Cairo.
Okay, so this was an educational program today. This was a very informative program, and most of all, we just wanted everyone to be knowledgeable and have fun and enjoy themselves today. And so today was about workers' comp, and if you feel that you may have a case or concerns, then Goldberg, Weissman, and Cairo, give SEIU Local 73 a phone call at 312-588-7630, and we're winding down right now. We want to thank you very much. We hope you have a beautiful week and weekend, and we want to catch you next week, everybody. Same bat time, same bat channel. Enjoy yourself. This is Charlie Bonds, and this is SEIU Says.